Good evening, America. This is Jeff Desk. The appeals court in New York has set aside the roughly $500 million civil fraud fine imposed on President Donald Trump. To put this in context, the decision comes from a case that New York State launched back in 2022, where officials accused him and his organization of inflating asset values to secure favorable loans and insurance terms. In 2023, the trial judge determined that liability existed on those points. Now, NBC News senior White House correspondent Garrett Hack is here with us. Garrett, can you clarify what this decision actually changes? We're looking at both the financial penalty and the underlying finding of wrongdoing. That's correct. This appellate ruling focuses solely on overturning the monetary sanction, around $500 million in total. The core determination that fraud occurred remains intact. The panel from New York's appellate division, the intermediate court, not the highest one, concluded that the size of that penalty crossed a line, violating protections against excessive fines under the Eighth Amendment. They viewed it as disproportionate given the circumstances involving President Trump and his companies. Let me paint the picture for you. The courtroom fills with tension. Everyone's attention fixes on the former president. Then in a flash, he raises his hands in exasperation and strides toward the exit. Reports confirm that former President Trump did indeed leave the session during his civil fraud proceedings. Secret Service personnel hurried to follow, and the room fell into stunned silence. Moments like this force us to ask, what happens when a high-profile figure decides the process no longer suits him? When someone in such a position acts as though standard legal obligations don't apply, it challenges the very foundation of fair proceedings. Court officials hold significant power to maintain order. If a participant attempts to disrupt or mock the setting, judges can respond decisively. They might direct security personnel to secure the doors and state clearly that no one departs until permitted. They also retain the ability to issue warnings of contempt proceedings or even detention for noncompliance. Analysts following these developments express growing concern about Trump's repeated boundary testing in legal settings. He appears to operate under the assumption that conventional expectations bend for him. This pattern fuels widespread discussion about potential escalations in his various cases. Consider how courtroom dynamics shift under pressure. Frustration mounts, yet protocols demand adherence regardless of status. So far, no judge has directed personnel to physically prevent Trump from departing in this particular matter. Still, speculation about that step persists, and it feels as though preparations are underway for a direct confrontation. During the New York civil fraud proceedings, the atmosphere turned particularly intense. After the court rejected a key request from the defense, Trump gestured sharply, announced his departure, and proceeded to walk out. Observers, including journalists from major networks, captured the audible surprise that rippled through the space. Agents assigned to his protection rushed to keep pace. In many ways, it resembled an impulsive reaction rather than a calculated legal strategy, a one-time leader abruptly abandoning his own hearing. Adding to the strain, he had recently faced another penalty for breaching restrictions on public comments, and the court had turned down an effort to end the case early. Clearly irritated, perceiving bias arrayed against him, he chose to exit, leaving his attorneys to manage the aftermath without his presence. This incident prompts serious reflection on what could unfold in higher-stakes criminal proceedings. Suppose a similar exit attempt occurs where incarceration looms as a possibility. The fallout might grow chaotic, with arguments emerging that absence undermined a fair defense. That's precisely why maintaining control becomes essential. Courts cannot permit participants to come and go at will. Should Trump or his counsel stage further disruptions, a judge could impose firm measures, directing officers to seal entrances, emphasizing that proceedings continue until concluded, and cautioning against defiance through contempt findings or custody. Such actions would serve as a stark reminder: the courtroom demands uniform respect for procedure, not theatrical departures. Media attention on these episodes only amplifies the debate. Discussions among legal observers explore responses if walkouts recur. Online platforms feature breakdowns of judicial options for securing a room. Social channels circulate clips imagining a point where a judge declares limits and enforces them. What's notable is that this remains grounded in reality. Officials presiding over Trump-related matters have grown stricter, issuing repeated cautions about penalties for rule breaking and signaling zero tolerance for interference. When we consider possibilities like secured doors or contempt threats, they sit firmly within the range of realistic outcomes. Continued pressure from Trump, treating judicial settings as optional or inferior, could readily lead there. We're approaching a critical juncture. The contrast stands out sharply. A leader accustomed to exiting difficult situations on his terms, convinced of immunity from repercussions, now confronts officials empowered to insist on accountability. Judges can halt such escapes and require full participation. That fundamental friction drives the current buildup, and its resolution appears poised to carry major weight. In today's discussion, we examine the details of Trump's courtroom departure, the legal basis for judges to restrict movement and warn of detention, and informed views on the extent of that authority. At its core, this touches on a vital issue. Can institutions effectively demand compliance from a former commander-in-chief who views rules as negotiable? Many will recall how this case echoed through the election period, with frequent criticisms directed at the presiding judge in a non-jury format. That tone resurfaced recently in a post on his platform, framing the appellate outcome as a full win for him, his family members, and the business entities involved. The reality proves more nuanced. Questions linger about whether the state will press onward or if further challenges will target the fraud determination itself. Nevertheless, Trump and his sons, who oversee operations during his presidency, have embraced the ruling as decisive vindication. They persist in characterizing the entire action, led by Attorney General Letitia James and overseen by a state jurist, as motivated by politics rather than merit. Let's recap the key events. We're examining the civil fraud matter in New York, centered on allegations that asset valuations were deliberately overstated to obtain advantageous financial arrangements. Billions hang in the balance, along with the viability of his commercial holdings. In civil disputes, attendance isn't typically mandatory for defendants, yet Trump has chosen to appear regularly, transforming the legal venue into a platform for broader messaging. This approach has complicated matters further. Repeated violations of communication limits, public criticisms of the judge and prosecutor, and coroner statements have shifted focus from facts to spectacle. The presiding judge, Arthur Engoron, reached a point of clear exasperation. Multiple sanctions followed for disregarding directives against targeting court personnel. Defense requests met consistent denials. Patience wore thin. On the day in question, attorneys sought an immediate dismissal, contending the evidence fell short and warranted ending proceedings without completion. The judge declined firmly, insisting the matter proceed. At that point, frustration boiled over. Accounts from those present describe him lifting his hands, stating he was finished, and heading out mid-session. The room reacted with visible astonishment. Such behavior defies standard decorum. Visualize it. Dissatisfaction with a decision prompts an abrupt exit during ongoing arguments. This aligns with a familiar approach, departing when circumstances turn unfavorable. Protection detail personnel moved quickly to accompany him, creating momentary disorder as onlookers processed the development. The episode reveals much about underlying attitudes. Across careers in commerce and public life, walking away has served as a frequent response to adversity. Yet judicial environments differ fundamentally. They possess mechanisms to require presence. Attempting to circumvent that invites repercussions. In this instance, he eventually returned, and the process advanced without him, as civil rules allow non-attendance. Still, the gesture underscored a perception of judges as adversaries rather than neutral arbiters. Now shift to hypothetical criminal contexts, where presence becomes obligatory. Should a comparable move occur amid serious charges, reactions would intensify. Commentators weigh those scenarios carefully. Criminal benches command greater leverage, directing compliance, imposing contempt sanctions, or authorizing restraint when necessary. Online commentary and analyses highlight precisely this prospect, a jurist responding to an exit attempt by ordering security to prevent departure. Consider the dynamics at play. Courtrooms grow charged and officials hold tools to preserve decorum. Contempt authority exists, potentially leading to immediate custody. For someone who has openly questioned judicial legitimacy, stronger enforcement may become inevitable to underscore that departures aren't permissible. Envision a criminal setting where developments sour, a damaging account, an adverse ruling, unfavorable presentations. Frustration peaks, prompting a move toward the exit. The judge intervenes, instructing personnel to secure passages. Departure halts instantly. Continuation becomes mandatory. Defiance at that stage could trigger on-the-spot contempt, leaving counsel momentarily at a loss. Officers would enforce the directive, compelling return to place. For an individual whose identity centers on autonomy and never yielding, this reversal would prove stark. Forced engagement rather than chosen withdrawal. Observers note this trajectory gains plausibility as tolerance diminishes. Repeated provocations, departures, criticisms, order violations narrow the margin. A firm boundary seems imminent. Respect the process or face defined outcomes. That decisive step hasn't materialized yet, but persistent escalation edges closer. Conviction and personal exemption may soon meet unyielding institutional response. As pressure mounts, judicial restraint appears near its end. Enforcing norms isn't merely punitive. It's about affirming that escape routes roots close when accountability demands attention. Should that threshold cross, expect intense reaction. Outrage labeled as overreach, accusations of bias, claims of victimization. Yet judicial prerogative stands as bedrock. Defiance carries tangible risks: intervention by security, contempt findings, potential custody. This positions a profound standoff. Preference for evading scrutiny versus commitment to mandated participation. The outcome will signal much about institutional strength. If compliance prevails, it reinforces equality under law. If evasion succeeds, questions arise about enforcement consistency. The Secret Service element adds complexity. Lifetime detail prioritizes safety above all, not courtroom compliance. In a standoff, judge directing restraint while protection insists on mobility, conflicting duties emerge. Orders from the bench hold legal weight, agents cannot facilitate violations. Practically, perceived threats might prompt intervention regardless, raising risks of direct confrontation between federal protectors and court officers. Such a clash would mark unprecedented strain, highlighting the singular nature of a protected former leader under scrutiny. Beyond one individual, broader concerns surface. If disregard for authority proceeds unchecked, exits, attacks on officials, rule breaches without penalty, it normalizes treating courts as partisan battlegrounds. Future figures might follow suit, eroding foundational respect. Courts depend on voluntary adherence even amid disagreement. Handling this case will establish lasting guidance. Firm enforcement would affirm that influence yields to impartial process. Leniency might imply status overrides obligation, a dangerous precedent diminishing democratic foundations. The matter transcends personal stakes. It tests systemic durability. We'll continue monitoring developments across these challenges. This is Jeff Desk. Stay awake, America. We'll see you in the next one.